Again, good morning to everyone. This is a day that the Lord has made. Let us rejoice and be glad in it. I am Judge Shauna Graves Robertson, and on behalf of the National Judicial Council, we would like to welcome you to our third session. We kicked it off in style on Monday, talking about ethical standards. We had a rousing panel, and it was so good that we had problems breaking for our luncheon. We followed that up on yesterday, and we had a fabulous panel that talked about transparency and accountability. Again, the questions were many. The discussion was interactive. We learned on the local, national, and international level that we are not so different, that in fact we have more similarities than differences. And today, we have our third CLE session, and I know that it is going to be as good as the other two, and perhaps maybe even better, Dean. All right? So in this morning's session, our moderator is Dean Alfreda Robinson, and she is ready to do her thing. In fact, I said, do you want me to kick it off, or will you introduce your own panel? She said, I am prepared to introduce my own if there's no one to introduce me. So this is not an individual that needs to stand on a lot of ceremony. She's ready, prepared, she's capable, she's able, and so I am going to bring her up. I will then let her introduce the panelists as we talk this morning about the very important and timely topic of human rights. Dean.
Thank you, Your Honor. It is a rich pleasure and privilege for us to be with the Judicial Council. I don't think I've missed a midwinter meeting I can't even think the last time I didn't. It's always a pleasure. Let me say that the Law Professors Division is delighted to be with you. We thank you for your very kind invitation. We know you could ask others, and so we don't take for granted that you have done this. I want to start off. My name is Alfreda Robinson. I'm the chair of the Law Professors Division of the NBA. I'm an associate dean at GW Law School and also the chair of our Judicial Selection Committee. I want to as well thank the Honorable Denise Langford Morris for her very kind invitation, the entire Judicial Council, of course, and the National Bar President, Pat Rozier. We thank as well our host committee. You've been enormously attentive to our needs, and we are delighted to be here. We thank the King, the judges, and the Kingdom of Morocco. Our panel this morning, and we received our specific charge from the judges, and we're going to do that. The panel is going to focus on national applications of international human rights. We will begin a conversation, we hope, that will extend over the lunch period and also throughout the week. And then, of course, when we leave here, on the international human rights law discussion coupled with a comparative analysis of national implementation of the International Convention on the Elimination of All Forms of Racism, and then hope that we can cover examples of ways that the international human rights law is relevant to judges and lawyers in the national context. Here it is my pleasure that we have two of the superstars of international law. They are active members of the National Bar Association, and we are, of course, right at the beginning, in the middle of our academic year, but I asked them if they could get permission from their deans to squeak out some time out of their schedule to present to us. Our first speaker is George E. Edwards of the school's Program in International Human Rights, which in July 2011 was awarded special consultative status with accreditation to the United States Economic and Social Council. This UN status is awarded to only 2,000 organizations from 200 countries, and he was the founding director. Thank you, George, for coming, and if you could give him a round of applause. Our second panelist is Rachel Anderson. Rachel Anderson is a professor of law at the Boyd School of Law at the University of Las Vegas in Las Vegas, Nevada. Like George, both through study, research, and teaching, she has become an expert in international law. She focuses her scholarship and teaching on business law, civil and human rights, empirical legal studies, and then, of course, international law. She is a newly minted president of the NBA's Las Vegas chapter of the National Bar, and is a member of the Executive Committee of the Law Professors Division, and also she is a member of the NBA's Judicial Selection Committee. Thank you, Rachel, if you could give her applause. Their comments for a certain period, each one, and then we're going to open up the floor to questions. We believe that we can have a very robust conversation, commencing with George Edwards. George?
Good morning. It truly is my honor, it's a privilege to be here in the Kingdom of Morocco with the judges from Morocco, with law professors from Morocco, with National Bar Association judges and members here. I'm delighted to talk about an area of law that's very special to me, that's very close to my heart, international law. I have been involved in this area for many years, and I'd like to share with you my thoughts about international law and how it relates to the domestic law that the judges of the United States work with and that the judges in Morocco work with as well. So I will talk about international law, and I'll talk about the relationship between international law and domestic law as kind of a primer for my discussion about international human rights law, which will lead into Professor Anderson's discussion about a specific area of international human rights law related to discrimination based on race. But I'd like to talk with you and present you with a general picture that I think will be very helpful in understanding the more narrowly focused discussion that we'll have immediately after mine. And then I'd like to talk about diplomacy and how diplomacy provides a remedy for some of the international human rights law violations that we encounter in the country from which I come, the country I'm in, the countries around the world, because I think there's no country that's free from human rights violations. And I think diplomacy is one mechanism that might be used to help resolve some of these problems, but it also may be used to present some of these problems from occurring. And I would suggest that diplomacy is something that not only those at the highest level of government are involved in, but diplomacy is something that we in this room are involved in. And I'll try to explain to you the different types of diplomacy: traditional diplomacy, public diplomacy, and citizen diplomacy, and how we as law professors, as students, as judges, are involved in a process that promotes the rule of law, that promotes human rights protections. I'll talk about international legal education and legal exchanges and how that also promotes international law, the rule of law, peace, security, and human rights. And I'll provide some details about how some of us in this room have participated in these, how, in fact, we all at the moment are participating in an international legal exchange. And I'd like to suggest again how that furthers the broader goals of international law and international human rights law, but also the more specific goals and that we'll be hearing about when we talk about domestic implementation of these international norms. I'd like to talk about, again, diplomacy, not only in one's home country, but outside of one's country, and then I'll provide some resources that we in the room might use as we carry on with our work in our respective countries, but also internationally. International law versus domestic law. Well, I think that most of us, certainly everyone in the room, is familiar with these broad areas of law that I have highlighted on the PowerPoint, different fields of law: public international, public administrative law, private law, criminal law, tort law, property. In our first exposure to law, in our first year of law school, we learned about these areas of law. These, I suggest, are domestic law, but I'd like to draw a distinction between domestic law and international law. Now, when we have sources of law, we're asked when we're in school, when we're on the bench, about sources of law. And domestically, there are numerous sources of law, and I've listed some sources of law in both the United States and Morocco and in other parts of the world, again, to try to draw the distinction between domestic law and international law, because again, shortly we're going to hear about how international law, how the treaties that Professor Anderson is going to be talking about, how they apply domestically. But on the one hand, we have two bodies of law, domestic and international. On the other hand, we have a merger of the two when we talk about human rights. So domestically, we have national constitutions. The U.S. has one, the Kingdom of Morocco has one. Within the United States, we have 50 states, and each one of those states has a body of law. Each one has a Supreme Court, statutes, courts, etc. And I would like to find out more about what the Moroccan system is, whether there are provinces here where there are different bodies of law. I don't know the answer to that, and that's one of the reasons that we're here to learn from the Moroccan delegation. We have executive orders in the United States where the head of government of the United States may issue an order, and that order is binding on those in the country. And I think you have executive orders here that come from the top down. And clients that do business outside of their home country, or they may represent non-U.S. Companies that are doing business in the U.S., and so there may be international aspects to the transactions that they are involved in, but that's not really international, that's not public international law, that's more comparative law, that's more trying to sort out what the appropriate rule of law is that's going to apply to the contracts or the transactions. And it could be, if there, for example, is a trade contract between a French company and a German company, if there's a dispute, where will that dispute be heard? Will it be in Germany? Will it be in France? Will French law apply? Will German law apply? Well, that is kind of what the private international law side is about, and that's not what we're talking about today. We're talking about the public international law side of international law, and international human rights law is a subset of that. The public international law deals with, in the first instance, the manner in which countries relate to each other. In our situation, and it's about human rights, but there could be environmental law treaties, intellectual property treaties, international humanitarian law treaties, all on the public side. And in fact, we have the law of war, which is on the public side, and then we have international criminal law. So the rest of our discussion today will not be about the private side of international law, the business transactions. It's going to be about the public side, countries interacting with each other to promote and protect human rights through treaties, and then on the domestic plane, the government implementing the treaties domestically. Now, let's distinguish between international law and foreign law, because we often hear this term foreign law, but it's not the same thing as international law. Foreign law is made by the monarchs, the heads of states of different countries. And so the foreign law, if I'm a U.S. citizen, so to me, Moroccan law is foreign law. And the Constitution, the statutes, the ordinances, those are all foreign to me. And for those in Morocco, U.S. law would be foreign law. Brazilian law is foreign to both of us, as is South African law and Chinese law. But that's not international law. International law is as I described it, which is, because we're not talking about foreign law, we're talking about the law that governs relations between and among countries, not about what happens domestically in any country. Again, the sources are treaties, custom, etc. Now, international human rights law as a subset of public international law, what is it? Because that's critically important, because international human rights law serves as the basis for the second half of our panel today, the discussion about the Convention on the Elimination of All Forms of Racial Discrimination. It's all international human rights law, but what is it? Well, we can trace international human rights law back eons. We can trace it back to the Codes of Hammurabi, to the Ten Commandments, to the Declaration of Independence, the French Declaration, but a nice convenient point would be the founding of the United Nations in 1945, when the international community decided that it was time to put an end to permitting states to treat people in their own countries in a bad way. So the United Nations was formed, and it promoted human rights, the rights of individuals to be protected from violations of humanity by their own countries. Soon after the United Nations was formed, the Universal Declaration of Human Rights was issued in 1948, and it listed out a laundry list of rights that were to be protected. They were divided into two different treaties: the International Covenant on Economic, Social, and Cultural Rights on the one hand, and then the International Covenant on Civil and Political Rights on the other. And those two became the principal binding sources of law that govern the manner in which governments treat their own people. And we're going to be talking about governments and how they treat their own people in the second part of the presentation. But the heart of that, the roots of it, are in these United Nations documents. To give you an example of some civil rights, we're talking about non-discrimination, freedom of association, freedom of expression, free movement, no harassment, no bullying, no violence to people. So protection of human dignity, no torture. That's a big one, and I've chosen torture as an example in just a moment. We have, on the other hand, economic rights, like the right to food, the right to housing, the right to property, the right to proper working conditions. So civil, the print is very small, but I highlighted in red the Convention on the Elimination of Racial Discrimination as one treaty that both the United States is a party to and Morocco is a party to. So Morocco and the United States have parallel obligations under this international treaty. And I have 8 or 9 other treaties listed here. And I don't know if you can see, but in some of the right-hand columns, I have an R. That means that the United States or Morocco ratified that treaty, so they're bound by it. And in some instances, we have an S, which means that one of the countries signed the treaty but did not ratify it. So you'll have an opportunity to view this slide more closely in your materials, but I wanted to give you a sense that the United States and Morocco are party to the treaty that's going to be at the heart of the discussion by Professor Anderson when I finish. Now, again, international law on the international plane and on the domestic plane, as I said before, relations between and among states, and then also international law trickling down. Is international law part of U.S. law? The answer is clearly yes. International law is provided for in the Constitution of the United States. There are congressional mandates that invoke international law, and then our judiciary, from time to time, looks to international law. So international law is a part of the law of the United States. No, international law is not wholly imported into U.S. domestic law, but international law does play a role in U.S. law. Now, on the Moroccan side, I'm sorry, I'm not an expert in Moroccan law. This is a question that I posed to the Moroccan judges, the Moroccan lawyers. What is the relationship between international law and the domestic law of Morocco? I think that might be an interesting question to discuss in the question and answer period. So I'll give you a few minutes to think of your answer. Okay. the relationship between international law and domestic law, I've chosen one example, the example of tort law. And I've chosen torture, because I think many of us know, even if you don't know the definition of torture, if you were to see or to hear about an example of something that might be torture, you might say, well, I know torture when I see it. But if we do have a situation of torture, when would, and under what circumstances would it be prosecuted? How do you classify this offense? Is it a tort under U.S. law? Probably, yes, maybe under Moroccan law. If maybe there are some ways to recover for this violation under the civil law of different countries, possibly. Is it a crime? Yes, torture would be a crime in the United States. I don't know if torture is a crime here. Presumably, it's a crime in every country. Is torture an international human rights violation? I would say yes. One of the treaties I pointed to was the Convention Against Torture that both countries are a party to. So that would be another avenue for seeking a remedy for a victim of torture through the international human rights law mechanisms. And then if, for example, we had an armed conflict and international humanitarian law were applicable, that would be another avenue for exploring a remedy in the situation of torture. So we have multiple bodies of law that may govern in different circumstances depending on a number of factors. We have relationships in this diagram between and among those different areas of law. Again, you can see this in the handouts. Remedies, my fourth remedy that I have in red is diplomacy as a remedy, diplomacy as prevention. Again, I'll tell you now a little about the end of the presentation. The end of the presentation, I'm going to tell you that we are all engaged in diplomacy as we speak, and I believe that the diplomacy that we're engaged in might further remedies, but also might further some prevention of human rights violations in our respective countries, because I think we're learning a lot about international law, about domestic law, about the things that we as members of the legal profession might do to further the rule of law and human rights. So diplomacy, what is it? We have three types: traditional diplomacy, public diplomacy, and citizen diplomacy. Three types of diplomacy. All of them promote the rule of law and human rights. Okay, traditional diplomacy is when one country tries to influence another country, so government leaders. So you may have the foreign minister of one country meeting with the foreign minister of another country, the ambassador of one country meeting with an ambassador of another country, the head of state, Voice of America, or through other kind of propaganda sorts of activities where one government is trying to influence private citizens. And the third, as you can imagine, is citizen-to-citizen diplomacy, where citizens of one country, private citizens, engage in activities, interaction with private citizens of other countries. I think certainly we are engaged in citizen-to-citizen diplomacy, but perhaps we have some public diplomacy happening here. I don't know what the support is by one government or the other, and maybe in order for this conference to come about, there were interactions at the highest level. I don't know what happened behind the scenes, but I wanted to give you an idea of these three types of diplomacy because I think they further the international human rights law that are at the heart of our discussions. So again, traditional diplomacy, you know what that is, country to country, some examples, ambassadors, etc. And then we have public diplomacy, and I think we have a hearty public diplomacy program in the United States, and I'll tell you about some of those because I think, well, first of all, I know that some in this room have participated in some of the public diplomacy projects of the United States, and presumably, well, and I would like to think, I would like to hope that more of that happens, and I have some examples of that shortly. Citizen diplomacy, again, people to people, and again, I suggest that diplomacy promotes peace, security, fundamental freedoms, and human rights. Some examples of how we in this room might participate. We have U.S. legal exchange opportunities for Moroccan judges and Moroccan lawyers. So what are some things that Moroccan judges and lawyers can do in the U.S. legal education arena that would promote human rights and fundamental freedoms. I have some degree opportunities. As Dean Robinson mentioned, one of my areas is international legal education, and I do believe that international legal education does promote what I've been talking about, the diplomacy and human rights. So in the United States, we have 3 basic law degrees: the Juris Doctor degree, which is the fundamental, the baseline degree, the first law degree that's offered in the United States. Then we have the SJD, which is the highest law degree that we offer in the United States. And then we have Master of Laws degrees, LLM degrees, that are principally for international students who come to the U.S. To study for 1 year. And those international students, those non-U.S. students, they may be law professors who want to do an LLM degree because they want to advance their teaching career. They could be students who are interested in working in the corporate world. Maybe they want to work for the United Nations. Maybe they want to further their ability to become judges or to further their judicial careers in their home countries. So these are things that international students can do in the United States, supported by the United States government, supported by schools. We have lots and lots of these programs, 150 or so in the United States. And these are some of the requirements for entry into the programs. And we have non-degree opportunities, and maybe this is more attractive to some Moroccan judges and lawyers who want to come to the United States to be involved in public diplomacy or citizen diplomacy, again, to further their understanding about different cultures, to learn about law, to share about the legal traditions in Morocco with people in the United States, with lawyers and judges in the United States who want to learn about your legal culture. But the United States Department of State, as the U.S. Department of State, has many opportunities, and you'll be able to find the websites on the printed materials here. And you can also visit their offices in this city and in Casablanca and Rabat. And there are many, many opportunities where you can go and spend 2 weeks at the invitation of the United States government in the United States, visiting the U.S. Supreme Court, the Supreme Courts of different states, law professors at different universities, and again, share your knowledge, your insights about Moroccan law, and then learn firsthand on the ground about U.S. law, so that when you come back to Morocco, you have an understanding of legal culture outside of your own. And I think that you will have left a positive impression on those you meet in the United States, as the Moroccan judges have left a positive impression upon those of us who came from the United States to hear this week. And I think that's one of the principal reasons that we're here, doing this sort of international legal exchange, so that we can learn from each other. And it works in both directions, so we'd like to see you in the United States soon. And so there are many opportunities, and I spell out some of those on the slides. And in diplomacy, the NBA Judicial Council being here with the Moroccan judges, this is what I think this does further all of the goals that we've been talking about, and that I think that Professor Anderson will talk about as well. Now, I'm going to end by just talking about a couple of examples of ties between the U.S. and Morocco. I don't know if you can read the Arabic there, but the Moroccan American Commission for Educational and Cultural Exchange. You can find the link, but on my website. So for both U.S. citizens and Moroccan citizens, this has been set up between the two governments to help facilitate these exchanges. We have the Tangier American Legation Institute for Moroccan Studies, which again promotes this sort of exchange and cultural understanding. We have the U.S. Middle East Partnership Initiative, MEPI, that provides local grants for program application assistance. There's a website for this as well. The Information Resource Center, an excellent resource for those interested in the United States. It's run through the U.S. Embassy here, and you can find out lots of information related to the United States, and you can, and if you are a U.S. citizen, you can go there to find out information about Morocco. And this is one of my favorites, Education USA. Over the past 4 or 5 years, once I was deeply entrenched in international legal education, I discovered this branch of U.S. State Department affiliates that fosters and facilitates student exchanges, that provides information, and there are Education USA advising centers in Morocco as well. And I'll end by just talking a little bit more, I'll give you 3 quotes from current leaders from the United States about the importance of international law, international human rights law, international legal exchanges, international legal education. I'll just pick one. President Barack Obama, in 2009, at a student roundtable in Istanbul, Turkey, he said, "Simple exchanges can break down walls between us, for when people come together and speak to one another and share a common experience, then their common humanity is revealed." And I think that comment was reflected in Dean Robinson's initial opening remarks about how when we come together, we learn about our similarities as compared to our differences. And with that, I'd like to just thank you very much for permitting me to be here today. And I'd like to turn the podium over to Professor Anderson, who I think will share some insights further along the lines of what I discussed. Thank you.
Good morning. So I am thrilled to be here. I am both humbled and grateful to have this opportunity to talk to all of you about the Convention on the Elimination of All Forms of Racial Discrimination. And I hope that I will be able to both give you some information about the United States and about Morocco and how the two countries have similarities and differences, at least at the formal level, in how they implement this treaty at a national level. I'll just tell you how we're going to proceed. So you should have for my presentation either 2 or 3 handouts. One that looks something like this without my handwriting on it, that has the overview of the slides for the presentation, and then the language of the treaty, either in English or in Arabic or both. And what I will do is I am aiming to get us to the place that you see at the very back of the handout, which is various questions one might consider for conversation. And those really just draw out opportunities or highlight opportunities for exchange among you. And so I will attempt to be brief, but I see that the clock is not showing me a limitation on my time. So I will not take advantage of that. I will put my watch here and, and glance down at it occasionally. So if I look away for a moment, you know I'm checking on that. And in the slides and in the handouts, which I'm about to turn to, you'll see that on the different pages, there will be text that is bolded. And so the handouts are very thick with information because I've tried to provide you with the legal sources for the remarks that I'm going to make, but I will not actually say in my talk everything on the slide. I will be going through the core points which are bolded, and you can always either make a note next to them or refer back to them at a later date if you want the relevant law or to go deeper into those issues. Today, as you know, I'm talking about the Convention on the Elimination of All Forms of Racial Discrimination. And this is a treaty that has been signed by and ratified by most of the countries in the world, making this a quasi-universal treaty and international norm. This is not always the case for all treaties, but it particularly is for this one. And both the United States and Morocco have signed and ratified the Convention on the Elimination of All Forms of Racial Discrimination, CERD, which I will now call it from now on. CERD creates obligations for the signatory countries, which requires them to eliminate 2 types of discrimination. It requires countries to work to or take affirmative steps
to eliminate intentional racial discrimination and also to eliminate racial discrimination that can be seen through the effects of different behaviors and practices. And it protects and promotes equality in a wide range of areas. And one of the particular characteristics of the CERD Treaty is that as the CERD Committee, which is the UN committee that is responsible for reviewing the reporting documents from each country, which are required to be submitted every 2 years, although countries often combine their submissions together and so may make multiple submissions at one time, the CERD Committee has over time been gradually but consistently expanding the scope of coverage of the CERD Convention. And you'll see also here that the CERD covers not only public sector actions, but also private sector actions. And I'm sure that for the US judges here, you've already heard several things that will feel, initially, you'll be wondering, how does that fit in with US law and how we understand it? And so I'm going to talk about that a little more specifically because if we think about, actually I'll flip, oop. If we think about both the US and Morocco, the countries have implemented the treaties differently. And I will say in advance, in relation to my remarks to Morocco, that I am not an expert on Moroccan law, that I have reviewed the relevant documents, but I certainly cede the authority to the Moroccan law, to the Moroccan officials in the room. So it includes a range of areas, and you'll see here everything from education, housing, voting, a wide variety of categories, and it includes an ever-expanding group of people, both general categories like citizens and non-citizens, but also specific categories like African Americans or Roma, and so you can group and slice in a variety of ways and still be covered by the breadth of CERD. So under CERD, discrimination, as I said, or the discrimination that CERD covers is both intentional discrimination as well as discrimination in terms of the effects. And I know every time I say this, at least the US judges should be saying, wait, but our laws don't cover that. But I'm going to talk to you about how I think that CERD and our laws actually do incorporate that, and I'm going to rely, when I talk about that, on the core documents that the United States submits in relation to all treaties to the UN, and the recent submissions from the United States for our reporting obligations, as well as for the core documents, and I will go to the exact language that the United States has submitted in terms of how CERD can be and is implemented in the United States. So these are relatively recent submissions under our current president. So discrimination purpose or intent, and it affects rights that are both political, civic rights, economic, social, and cultural. And the term dissent is particularly important when we talk about the CERD jurisprudence. And countries can submit their documents to CERD, so they're required to state reporting. Some countries have implemented Article 14 of CERD, which allows individuals in their countries to also submit claims. Morocco has done so. The United States has not. So if you are a Moroccan citizen and you can submit to the CERD committee, of course you have to exhaust national remedies. If you are in the United States, you cannot do so, so the United States has not agreed to that. The term dissent has been looked at very closely by the CERD committee. And one of the questions in thinking about the term dissent was, does this overlap with national origin and ethnicity? Is this all the same thing? But in fact, the CERD committee came back, and for the United States, as well as for other countries, this is particularly important. They said that dissent can also mean that you belong to a community that is affected by rigid social stratification. So a system of ongoing practices that then have a discriminatory effect on a group of people. You can also have discrimination based on multiple grounds. In the United States, we might talk about this as intersectional discrimination or otherwise, but in the CERD context, we talk about it as double discrimination. And the indirect discrimination, right, is that discrimination based on effects. And so this just goes more into how we understand dissent differently, and whether you have the broader interpretation or the more narrow interpretation of dissent. I will leave that as background information, but not go into more depth here. What CERD also offers that is very important for, in particular, the United States jurisprudence, right? Because we have to think about Morocco implementing directly, the United States implementing through its own laws and practices, which means we need to look to see how we actually filter that in, right? So it's more complex to figure out where CERD fits into US law. Under CERD, special measures can be taken to remedy discrimination, both the intentional and effects discrimination. And you can think about this similar to United States affirmative action. And in fact, the United States government, in its core documents and reporting to CERD, has talked about how we understand affirmative action in the context of special measures under CERD. So CERD allows the special measures as long as they are, as we would understand them, right, targeted, they're limited to that purpose, and you discontinue them when you've actually achieved your goals. CERD also addresses non-citizens, and in essence, CERD says you don't have to have the same laws for citizens and non-citizens, but you can't discriminate against the non-citizens, so treating one. So first, the United States, and US law will explain or help us understand why the US might make these reservations, because they fit with how we understand our legal system to work. So any laws that are passed by the United States, right, are supposed to predate or pre-exist the CERD, because the U.S. entered into it later. And so the U.S. made reservations to preserve the functioning of the U.S. federal system, and said that no legislation or other action that is incompatible with the U.S. Constitution will, right, trump U.S. law. And so we have to look very closely when we figure out how the two will interact. So under the U.S. reservations, the United States said that the enforceability is dependent upon the U.S. Constitution and U.S. laws, and in effect, that what the U.S. also said was, and here we have this from the recent core documents and state government reports, that although the United States said in making a reservation when entering into the treaty and when ratifying the treaty, that no laws that are inconsistent with the U.S. Constitution or laws will, right, have automatic effect, we might say to ourselves, so does that mean that if the United States does not have a law implementing CERD, that CERD is not effective in the United States? We might ask that question. We know, for example, for the Genocide Convention, that the United States then implemented legislation effectively implementing that convention. What the U.S. government has said in its more recent submissions to the United Nations is that there are contexts, for example, the International Convention on Civil and Political Rights, that if there is legislation that needs to be enacted to make a convention effective upon ratification, that U.S. practice is either to pass that legislation before ratification, or sometimes to take action after, but that the lack of legislative action altogether in relation to a treaty that has been ratified can be, and is, for example, with the International Convention on Civil and Political Rights, can be evidence that CERD's obligations are already a part of U.S. law. And I would posit to you that there is an argument to be made then that those areas of U.S. law that are identified as being already implementing CERD can then be supported in their implementation by reliance on CERD treaty obligations. I posit that to you as an argument. The CERD treaty also preserves the federal system, and what we know from the U.S. context is that sometimes the federal government protects laws more broadly and drives the country forward, and sometimes it is that states implement laws that are broader than what the protections that are broader than what the federal government has set out as a minimum standard. So when we talk about this issue, and here I come to the component where we talk really about the judiciary and the judicial council, when we think about the fact that no legislation or other act that is incompatible with the U.S. Constitution and laws is applicable or effective in the CERD context, what we are saying is that, in part, what we are saying is that this is an area where the judiciary has the power that the judiciary has in the various countries, which is to interpret how that law fits together. And at the executive level, in the submission of the core documents and the biannual reports, the executive has said this is an area where the judiciary can determine and interpret how these two fit together, the U.S. laws and CERD. And I'll give you a few examples of how that's taken place so far, but at the moment there's a limited number of cases. And they give us the factors that you should look at, including the terms of the treaty, the structure, the history and subject of the treaty are things that go into the interpretation. So we will skip forward now because I've covered these things in what I was saying. I would note briefly that when the CERD committees review the periodic reports from each of the countries, they talk both about positive developments and they also talk about things that they hope would be addressed. Now, for both Morocco and the United States, you will see that it's not from this year, right? So thing we could talk about now, right? Because of, you see the date on this from 2010, right? So that's a few years back, and a lot of things have happened since then. Also for the United States, you'll see that this is an older report, right? So we have new submissions from 2013, but those have not yet come out from the committee. And so two of the things I'd like to highlight from the U.S. were, at that time, the reauthorization of the Violence Against Women Act and the reauthorization of the Voting Rights Act were things that specifically the CERD committee had highlighted, and of course we know in the United States that some changes have taken place since then. So now this I've put as a question, and George and I agreed to do this in parallel to open up this space so that we took the opportunity of direct diplomacy and direct interactions to open up the question for the discussion between the different judges and officials about how Moroccan law on the ground actually implements, which of course is always, we all know, different when you have every court each day and the exact specifics of how the judges are viewing that. So we wanted to leave the space open for that conversation. When we talk about, I think, have I gone backwards? Wait, there we go. Okay, so if we turn to the context of U.S. case law, I want to give a few examples of where we have seen the CERD mentioned and implemented in U.S. case law and some of the ways you might see it addressed. But since the documents that give more clear guidance from the U.S. executive about how CERD fits into U.S. law, you may see that there are other opportunities for addressing the implementation of CERD in the national context. In the context we talked about, actually, let me go one further. Okay, so what we know is CERD is not executing and does not create a private right of action on its own, right? We have to actually see it in the U.S. law, but that may not be an inhibition if we know where in U.S. law we should understand CERD to have been implemented, for which the executive gives us guidance. CERD doesn't create a private right of action or a private cause of action for domestic plaintiffs, but U.S. law creates private rights of action where the executive has specifically told us, and I'll come to that slide in a moment, which U.S. statutes create private rights of action that they understand to fit in this international context. And then our domestic courts, in this one case, we see lack subject matter jurisdiction to hear a claim under CERD. But if you look at the sites that I've given you, you'll see that they vary in terms of how binding they are and in which jurisdiction. And so it will vary from state to state, obviously, unless we're talking about a Supreme Court decision. So where we see CERD implemented, we see CERD used as persuasive authority in U.S. cases, and we see that in a variety of contexts for the requirement of local exhaustion of remedies before reaching to international law, for supporting the objectives of affirmative actions, although notice that's the concurrence, and supporting international norms for affirmative action, but notice that's the dissent, right? That's the Gratz and Grutter. CERD as a prohibition against deprivation of citizenship or nationality based on race, as evidence of an international norm prohibiting this practice. So you see that U.S. courts are both hearing arguments and also using CERD in their analysis to determine what is an international norm or practice. We see CERD as persuasive authority in terms of what the definition of racial discrimination is and how that is viewed under international norms, and that there is an international consensus against racial discrimination. So we're seeing CERD slowly but surely being integrated directly into U.S. cases. It varies dramatically depending upon who the plaintiff is and who is making arguments. So sometimes the courts allow the plaintiffs to make the CERD claim and they include it in the analysis. Sometimes they say this is not relevant or applicable, or you haven't brought the right evidence, all depending. Sometimes they will accept the CERD report as evidence of a discriminatory practice. And in some contexts, the courts have allowed countries that wanted to present CERD evidence as a courtesy, but noted that they were not required to hear the country's evidence, but they chose to include that in the record. And we see that CERD has also been used in the context of determining damages, in the context of, I've already covered that, of death penalty cases, and the evidentiary component. UN manual for training of judges and lawyers in many of the proposals that I'm listing here, and I've noted where I'm drawing on the UN manual, and those are also available online with other related information. So one is awareness, so keeping an eye out for opportunities or where CERD could be applicable. And of course, I realize that judges are limited to a certain extent by what the parties have presented as arguments, at least in terms of what they may be determining, but we also know that courts will discuss things that parties could have raised if they had thought to do so, and how a decision might have come out differently if the parties had raised or addressed different issues, so fleshing out how an area of the law could develop, and so I note that here. We also have the opportunity of education, so as we're exactly doing now, we're able to get updates on the development of the implementation of international conventions in U.S. and in Moroccan courts and in other countries, and we see that that implementation seems to be growing in a variety of ways. And third, the actual application. And so we are starting to see, as I showed you from the U.S. context, courts beginning to discuss how CERD does or does not fit into that particular context. And then we have this context for the prosecutors, where the prosecutors can act on violations. So if they're aware of violations, and the UN actually recommends in every context of every violation that the prosecutors pursue it as a matter of course, so that the practice of always pursuing violations along the way is used as a deterrent. And of course, that that is their broader recommendation. I realize that the actual context in courts vary dramatically, but I note that is what they propose. And then the pretrial discharge, so a lot of conversation has been had about not sending people immediately into court, but actually making a choice about how to handle the cases before you implement the court proceedings, and that also exists under the Tokyo rules, and there are specific standards and criteria under Tokyo Rule 5.1 that help judges know how to make that determination. And then, prosecutors. And then in terms of the judges, there are several areas that have been identified as potential areas for implementation of the CERD treaty, and they include making determinations on the admissibility of confessions where racial discrimination or practices connected were involved in the securing of the confession, diversion and non-custodial members, which have taken on significant life in the U.S., and conversations about not sending everyone to jail or being incarcerated immediately. And there I would note that the United States has particularly been called up by the CERD committee for the significant difference in the number of African Americans and Latinos that are in prison as compared to whites in prison, and they have said that they view that as evidence of discriminatory practices, and so specifically recommend diversion practices and non-custodial actions as part of a way to address that. And then another opportunity is the interpretation of common law, or a context where you have a lack of law. So that's an opportunity for those contexts where one can talk about how CERD could or should be implemented, or how the case might have come out differently had the parties raised those issues. And then I gave you the one example of the court that was hearing the CERD arguments of a foreign government, in that case Mexico, to arguably develop or at least get a sense of the perspective of the foreign government, but we know that that also builds our understanding of how the treaty should be implemented.
This week, our focus has been, and our theme has been, the big story, lessons learned, and next steps in the collaboration on judicial reform. And so this week, we have shared with our Moroccan colleagues a lot of information on a lot of outstanding topics, and we've identified individuals that are going to summarize the various topics. And if you are here and discussed the area of transparency, who volunteered to talk about transparency this afternoon? Could you come forward, Judge Quince, please?
My name is Peggy Quince. I am a justice on the Florida Supreme Court, and this is Marcella Holland, and she is a judge on the
Circuit Court for Baltimore City, 8th Judicial Circuit in Maryland.
And our topic really at this conference was transparency and accountability with an independent judiciary. And we started that conference by indicating that there are many similarities and some differences when we discuss these topics between America and Morocco. But we found there were, in fact, many similarities, some of which include challenges that both of us face in this electronic age in making sure that our records are accessible to the public. We found that we share the same kind of challenges concerning the administration of our court system. We have challenges involving the budget that is given to our court system. In this ever-changing world, we find that our populations are increasing, but the number of judges are certainly not increasing to keep up with our population, and so we have caseload issues. We also found that mutually we have a lack of knowledge of our court system on behalf of the citizens. And yet, the very core of an independent judiciary, a judiciary that is not beholden to the executive or the legislative branch, is the public's trust and confidence in the judicial system. And therefore, we discussed such issues as judicial ethics. And we find that in both systems, we have a code that judges have to abide by. And should that code be broken, or someone believes that code has been broken, in both systems, there is a mechanism for people to bring their complaints against judges. But one of the differences that we found is that unlike in America, where if it is unfounded, that seems to be the end of it, here, a judge can actually bring some kind of counter or bring a suit if it's unfounded. And so we like that very much.
The judges all applaud.
You want to say something?
I just want to also note, it was not just Justice Quince and I. We were joined by Justice Sahim, who's been here the whole session. I wish he were here right now, because we want to thank him. He brought a wonderful presentation on the judicial reform in Morocco and the charter and the proposed changes to their judiciary. And he was joined by some of his colleagues from the Supreme Court here. And so we had a lively discussion and a great interchange. And the bottom line we decided was that while we have similarities and while we have differences, both systems' key goal is fairness and equality in the judicial system and better access to justice for all of our citizens. That's it.
Okay, would our colleague that moderated the ethics discussion please come forward?
Good afternoon. My name is Gene Thibodeau, and I'm the Chief Judge of the Third Circuit Court of Appeal in Louisiana. Avec moi l'après-midi est Juge John Houston. With me this afternoon is John Houston, who's a federal judge in the Southern District of California in San Diego. We were asked to do a comparative review of the Code of Judicial Conduct, the ABA Code of Judicial Conduct, and the Moroccan Code of Judicial Conduct, and the various 8 principles in the Moroccan Code of Judicial Conduct have really great corollaries in our ABA Code of Judicial Conduct, and Judge Houston is going to discuss that in more detail. Both have as their underpinnings 2 things. One, the concept and the practice, not simply a concept of judicial independence, and 2, the fostering of respect for the integrity of the judiciary. And with that, I'm going to turn it over to my co-panelist, Judge Houston, to give an overview over what we discussed this past week. Judge Houston.
Good afternoon. As indicated, I'm Judge John Houston. I'm a United States District Court Judge from the Southern District of California. It was a pleasure to delve into and share with all a comparison between the Code of Judicial Conduct here in Morocco with that of the ABA Model Code. We discussed during the course of our session the significant similarities between the 2 codes. From dealing with issues of integrity, independence, fairness, and judicial temperament and competence. We also discussed the evolution of the code. And we also learned that the Judicial Code of Conduct didn't start with those of us from the United States, didn't start in Morocco. It's age-old in its development here in the in the world, that is. The evolution of the judicial ethics through the centuries has informed us that people are highly sensitive to the processes of procedural fairness. And it has been no surprise that the perception of unfair or unequal treatment is the most important source of popular dissatisfaction with any legal system. Many people have not come into contact with the legal system, so that aspect of unfamiliarity breeds dissatisfaction or unfamiliarity with the outcome of what should happen in the process. And that in and of itself creates a challenge for the judiciary to make sure that any appearance, real or perceived, must bridge the gap that exists between familiarity and unfamiliarity. Judges can alleviate these notions or misgivings with respect to unfamiliarity by keying in on some very key elements that have been recognized through the ages with respect to confidence in a judicial system. The appearance of impropriety, procedural fairness, the act of being open to listen to both parties, irrespective of wealth, favor, position, status, neutrality or impartiality, and respectful treatment to all litigants before the court. This value of fairness is one that people expect and demand from judges, and the code in Morocco and in that of the United States is designed to meet those expectations. The confidence of the people who use our services has to be foremost. They have to believe in us. They have to believe in what we do as judges and how we do it as judges. So in that end, potential or suspicion of unfairness must be guarded against at all cost. And our respective judicial codes, in their fluid manner in which they're interpreted, assures that the public will feel more comfortable with the administration of justice. Perhaps it was appropriate for this conference to convene with a session on the judicial code, because the elements that we've discussed, impartiality, integrity, competence, all present a common thread that is run through, it runs through and connects every subject we've discussed here during the course of this conference. And it is with those elements that present to any country its most precious resource, its most precious currency. And I submit to you that we've learned at the beginning of this conference with the judicial code and everything else that have come through this particular conference, that most precious currency in any legal system is justice itself. Thank you very much.
And we want to share our appreciation with Justice Ayubi, who graciously gave his time, his talent, and his knowledge to making this a success. Just a quick observation. In the Moroccan code, there are two invocations to spirituality. In Principle 1, under independence, I note, and we don't have that, to achieve the result of independence, a judge should draw his or her powers from Almighty, the Creator. And on Principle 6, judicial conduct, another invocation. The judge must be of good, distinguished, and just conduct, which is one of the characteristics of God, who is utterly just. I suppose if we had that in our code, I'm sure that we would be probably talked to and talked about and referred to Amendment 1, the First Amendment. But at any rate, that is...
And we might be much better off, regardless.
So, thank you all.